Hi, and welcome back. Attorney Steve Vondran. We're doing another exciting video here on what to do when you receive a letter, what I refer to affectionately as the love letter, from the Business Software Alliance. Now, this is the BSA, is what we call it in the business, the BSA, Software Licensing Basics, and let's get going. Okay, so basically what happens is if you're using, lots of times the BSA is made up of Microsoft, Adobe, Dell, IBM, Symantec, McAfee, Apple, all these different computer software companies, these behemoths, these publishers, as we call them, software publishers. And what happens is if your company is using, like I said, lots of time you're looking at Microsoft, you're using their software without the proper licensing, server exchange servers, Windows, Office products, this, that, and the other. You don't have your CAL licenses. This is another big thing these days, your CAL server licenses. When you're accessing the server, you can end up getting a letter from Microsoft. Sometimes you get a verification letter that's asking you to, for lack of a better phrase, to true up, to show how many shortages that you have on your software. So, but like I said, your business can be going smooth one day and you get this letter and you're like, well, what do we do now? We have a letter from Microsoft, or worse yet, you have a letter from an intellectual property law firm that is basically saying, hey, by the way, there's a potential $150,000 per infringed copyright work, but we think we can work through this amicably, is what the tone of the letter might be. So what do you do? The question is, well, what do you do? Point one, don't panic. Don't panic. Some people will ask me, does this mean I'm going to jail? No, it's often like basically what you'll see on, let's go back here, we're not ready. But, sometimes is what you'll see, on TV. If you pirate a movie, there's that copyright symbol on the movie screen that says you could go to jail. But, in theory, yes, in theory, copyright does have a criminal component to it. In theory, that is always a possibility. We can never completely rule it out. But for the most part, you're looking at civil software infringement cases, unlicensed software, pirated software, using software without any licensing. Sometimes it involves illegal downloads off the internet and things like that. Sometimes it involves buying computers that already have the software installed on eBay or things like that, thinking that you're getting a good deal, or maybe you even bought it at a garage sale, things like that. So first point, don't panic. Threats of copyright infringement, yes, those are legitimate. You'll see that $150,000 per infringed work, that is under the copyright statute. There are attorney fee awards, so this is something that you do need to take serious. And point three here, don't call their lawyers before you have a chance to speak with a copyright lawyer. That's us. So, before you go calling them saying, what's going on? We're not doing this, or we're not doing that, or we only have 10 short copies, or, we just merged, our companies just merged, and we bought some company, they don't know what they're doing, and, we didn't do that as part of our software due diligence. Before you go and just start, letting their attorneys or their counsel, sometimes you may be dealing with some in-house people, before you're doing that, make sure you speak with a copyright lawyer to assess your situation, to see where you're at, see what your possible defenses are. And, we believe that we've put together a program that makes it so cost effective and affordable that you'll just say, you guys handle it. You guys just handle it. So that's the goal here. But don't go talking to them. Their lawyers will be taking notes. Those things may be used against you. You want to make sure that you're properly advised and that you're not just admitting to your willful copyright infringement, because then you may be looking at these serious damages. Next, confidentiality agreement. Again, this is another reason why you would want a copyright law firm on your side. We can help protect your settlement conversations. You're making representations. You're exchanging audit spreadsheets. You don't just want to go and say, hey, here's everything. We're admitting this. We're admitting that. You're just handing over the keys to the castle to experienced copyright lawyers. And, this could be used against you. So one of the typical things we try to do is to get an agreement for confidentiality. This is to seal up your negotiations so that the items, to the extent protected by law, they are protected under the Federal Rules of Evidence 408. Now, in case you're new to copyright law is federal. This is exclusive federal court jurisdiction in these copyright cases. And so these cases are brought in a federal court, like a district court in your state. So the rules that apply in a federal court, you're looking at the Federal Rules of Evidence. That's FRE 408 is the code section. And this deals with compromise offers and negotiations. And what it says simply, I took a little piece out of the code there just so you can see what it looks like. Evidence of the following is not admissible, meaning this is not admissible in a court of law. So if you end up in a lawsuit over the software infringement, your communications, if they're protected and identified as such, protected under FRE 408, the evidence is not admissible either to prove or disprove the validity or amount of a disputed claim. So, if there's a dispute as to whether or not you've infringed software or as to what you owe, those certain types of things are not admissible. So if it goes to court and they say, well, you offered up $500,000 to settle your company's infringement, you can say, look, that's simply inadmissible. We were trying to settle. We were working in good faith and trying to keep this case out of court, and I guess they got some information and now they want to go to court. So as you can see, you need to be very careful in these situations when you're dealing with these negotiations. The evidence can come in for other purposes, not in regards to the validity or the amount of the claim. Sometimes they can come in for bias and prejudice and some other things. But that's a general thing. You want to get your conversations protected by confidentiality agreements in writing, okay? And this is something a good law firm can do for you. Next screen, what do we got? Try to limit the scope of the audit. Okay, when we're talking about the Business Software Alliance, as I mentioned, there are many different members. You can see them there on bullet point 2, Microsoft, Adobe, Dell, Autodesk, Apple, Symantec. When you get a letter, oftentimes the letter will have on the bottom that, this letter is from the BSA, and the BSA is comprised of all these member organizations. And it will list, and usually in a footnote, all the different companies. And so oftentimes the person or company that receives these letters are a little confused. They say, do I have to do an audit of all my systems for all these different software products? That's quite a few. This could really get extensive and expensive. The answer is it depends. You have to negotiate it, and again, this is why you would want an intellectual property firm like ours to represent you in these cases, to try to limit the scope, to communicate with their attorneys and find out what the issue is. How did we get here? Was there an informant? What's going on here? Why do we have to go and for example, look to see if Autodesk, if I have AutoCAD, we're not an architect or an engineer. Why do I need to have that on there? Why do we need to search that? What licensing agreement is this based on? So, these kinds of questions oftentimes can be tough for the individual company or business owner to handle on their own. It can be intimidating. Oftentimes you are up against very seasoned professional copyright lawyers who do this for a living, and they know some tricks. Let's just say they know the tricks of the trade. So but one of the things we would certainly try to do, and again, you can never guarantee that this will happen. It really depends on what they believe is going on inside your organization. If they think you're pirating and selling software, you could be subject to a software raid. They could actually come to your business and get a search warrant. We had one firm not too long ago that said, your clients are subject to a software raid. And I said, well, we'll be fighting that all the way, and you better have some damn good evidence before, if you're going to go into a federal court, because we will be, trying to find ways to fight that. And you better be right if you're going in there. So those kinds of things. But trying to limit the scope of the audit is a very important part of what you need to do when you get one of these BSA letters. Next, we have assess the potential license shortages. What's going on? What do we really think the realistic exposure is? How many computers, laptops, and servers do we have? How many different locations are we talking about? If it's Microsoft, how many different people are accessing Exchange servers? Trying to make that assessment of what this is going to cost you. Assessing, proof of purchases. Does your organization maintain your proof of purchases? Do you keep them in a safe and secure area? We had one case where we believe the informant took the receipts, took the software, and the proofs of purchases, and then later turned in the company as a disgruntled employee. So these kinds of things will happen. You have to bear in mind that these things can be triggered by informants. Oftentimes, they will be triggered by informants, ex-employees, contractors that come to your organization, temp employees that are out there looking around. It could be anybody. So you have to look around. And sometimes we've even had clients that said, I'm pretty darn sure it's a current employee, and I think we know exactly who it is, and this is pretty pathetic. And you have to be careful, though. You have to be careful as a business owner, because bear in mind that there are whistleblower laws. There are whistleblower laws that protect employees that are merely informing authorities in regards to illegal violations, things that are going on in the workplace. So you have to be very careful not to just go and terminate some employee because you believe there's something wrong there. That could lead you into just as big a trouble as you will have with your copyright. Okay, so it's very important. Again, these are the things that we discuss with you when you retain our firm. We talk about these things and who the informant might be and what issues may be involved. There may be breaches of confidentiality agreements. There may be breach of severance agreements when an employee terminates with your company. There may be non-disparagement clause. There may be trade secrets at issues. So there's a lot of different types of things that can pop up in these software licensing cases. But a key here, as I mentioned in the pink and the purple, the willful infringement, realizing if you have some serious willful infringement, this is where the other side, the opposing counsel, is going to get very aggressive with you. They're going to smell the steak dinner, so to speak. So you need to be ready to make your case and try to minimize and mitigate your damages. But assessing your shortages and where you stand, some calculations come in there, what we believe you will end up paying based on our experience and whatnot, and we can help you with that when you call us. Defenses and mitigating factors. Again, this is sort of your pre-planning stage. You're thinking about what can we do, how can we protect ourselves, how can we minimize, or what I put there, rebut the case of willful infringement. Willful infringement is where they're able to go in to a court and start seeking large amount of damages. We had one case with a client buying and selling things on eBay that was alleged to be infringing, or an Etsy site, and they took a default judgment because there was some improper service of the summons and complaint, and the judge, based on just a couple items on the website, the judge entered a default judgment approaching six figures, I should say. So, I mean, the figures can get staggering in copyright law. Copyright law has a lot of protections for copyright holders. As you know, software companies, filmmakers, musicians, songwriters. Copyright law is very, very strong, and it's designed because you have some powerful industries. I mean, you're talking about the software industry. You're going to have a very powerful industry group that is, waging war against you. So these are very important cases that you have to take serious. But looking at your receipts, did you lose receipts? We've had cases where somebody got the software as a gift or a trade show giveaway or in exchange for services. So there's lots of different scenarios that may pop up as far as defenses are concerned. You may, when I say lost receipts, having an actual license is a defense, and sometimes people lose receipts. Sometimes we're talking about software that's old. That's 2007 or 8 versions of software. So it could be that. You may have bought something online, as I mentioned, at an auction site, thinking that it was a legitimate transfer of a license. You may be going back to the informant. There's issues with whether you're dealing with a career informant, somebody that is installing its software, running around and collecting rewards. Recently, I saw a piracy award site up on Facebook somewhere. We were looking at that, and they're saying, wow, now they're up on Facebook promoting turning in your boss and things like that. So, and I'm not saying just the Business Software Alliance, there's other organizations, but if you search report software piracy in Google, if you give that a search, you'll see that there's different links that pop up. Like I just saw one with the SIIA, Software Industry Information Industry Association, and they'll offer rewards as well. So you'll see these kinds of things out there. And sometimes you may have a career informant type of issue. Finally, could be a case of corporate sabotage, defamation. You could have somebody defaming you, saying you have all these shortages when actually you don't. In a case of like a copyright bully just trying to turn you in. And you may have violations of company policy, so forth and so on. So these are some of the things we look at. We have other defenses that you can see at softwareauditlawyers.com. and get some more information there, softwareauditlawyers.com. Request for evidence. The next stage, we will then be looking at, asking questions of the law firm, some things, or the BSA, some things that make them have to ask some questions here. Getting low on a battery here, so I got to keep it rolling. Did they verify? Did they meet with the informant? Did they discuss the case with the informant? Why are you being subjected to an audit? What software licensing agreements are we running under here that would justify us submitting to an audit? These kinds of things that have to be asked. And again, when you're handling the case solo, it may not be as easy to do as you think. And then inadvertently, you will end up in a discussion with the copyright lawyers, and you will find yourself oftentimes taking a big gulp and saying, I wish I would have called Vondran Legal. That's the firm I wanted to hire. But anyway, so let's go to the next one. From there, you're going to either submit your audit results, or in some cases where your exposure may be too high, if you have serious willful copyright infringement, pirating of software, massive downloads off some torrent sites, those kinds of things, you may decide to take ulterior plans as opposed to just admitting to all the willful infringement. So it really just depends on your organization and what's going on in there. Those are the things that we can look at. But submitting your audit results and trying to then negotiate a settlement. As I note on the third bullet point, yes, people ask, do they file lawsuits? Yes, you can see they do file lawsuits. They do from time to time file press releases. You don't want your company in a press release. And again, this is where a skillful intellectual property attorney can help you navigate these dangerous and treacherous waters. Okay, negotiation is the next stage. That is working through the deal, fighting for the best deal, using all the leverage that you have, all the defenses, all the mitigating factors, trying to create the strongest case possible to rebut your willful infringement, being patient and yet aggressive. And again, this is the art of negotiation. We do this for a living. This is why they pay us the small bucks, and this is why we do it. But we love this part, and this is where you really just want somebody on your side that's fighting for you, not caving in to very, very aggressive demands that you may run across. Finally, settlement agreement. Once the deal is reached, confidential settlement agreement is paramount. You don't want press releases going out. You don't want disparaging statements being made. As you'll find in most of these situations, these agreements are negotiable. There's lots of terms. There's lots of pages. This is contract law, so you really have to have a sound grasp and understanding of contract law. And you need to fight for favorable terms, and that's what we do. One of the key ones that always pops up is future audits. They usually want to come and conduct future audits at your expense and so forth and so on. So, there's lots of different terms that we negotiate. Also, payment terms. People ask us often, can we finance our software? Yes, usually there's a way to do that. We can tell you more about that if you give us a call. And also software code of ethics. Give us a call. We can tell you more about that. And any questions, again, visit us at softwareauditlawyers.com. Softwareauditlawyers.com is our website. We are different from other firms. We offer low flat rate fees. We are affordable. We try to get this job done. Our goal is to get this job done as painless as possible for a predictable fee. So you're not going to get a surprising legal bill after the case is over. You're not going to get a $10,000 bill. We do know firms that charge very large upfront retainers, $10,000, $20,000 before you pay them, before you say, I have to go do that because it just sounds fun to pay big, giant legal fees. Give us a call. We're happy to walk you through an initial consultation to discuss kind of the pros and cons and where we're at. But we believe, like a lot of other clients, that you will be happy with our services. We will take this pain off your hands. We do know what we're doing in this area, and we have helped a lot of companies, small and large, settle their software audit disputes. Okay, so that's about it. You have our phone number there if you need us, 877-276-5084. Don't forget to click on that red V for victory and subscribe to our YouTube channel. So we thank you for listening. We hope this has been helpful, and we will see you again. This is Attorney Steve Vondran. This is General Legal Information, and we'll talk to you soon.